Good boy. Sit, sit, good, 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 sit, sit, good.
Hi everyone. I think people have started joining in. Welcome to today's session, and really nice to see you all joining in so promptly and making time. Uh, I'm just let's give 2 minutes for everyone to join in, and then we can begin the session if that's okay. Okay, I think we can start now. Uh, I hope everyone is okay with starting now. Everyone's ready for today's session. So it's something I'm looking forward to because the topic is insights on the proposed bill to the PoSH Act of 2013. And there are amendment bills that are circulating on the PoSH Act. And for this today, we have on the panel Aparna and Shamali. So a little bit about the panel discussion itself. So we have been working with ILA, Indian Lawyers Association. We at Kelp have been working with ILA to provide you these webinars on different topics within POSH law and related topics to conduct panel discussions every month with experts in the field. So today we have with us Shamali and Aparna here. And Smita was supposed to moderate, but unfortunately, she is not well, though she's with us on the call, but she won't be able to speak much. So, apologies for that. And I will be your moderator for the discussion today. A little bit about the panelists here. Um, a little bit about the panelists here. Aparna is a person with 2 decades of experience within the posh with within the posh and HR spaces. She has been creating safe and inclusive workplaces and became a personal and professional when it became a personal and professional passion for her. with her mentor, who introduced her to the world of PoSH in 2013. She has dedicated 10 years of her professional journey to spread awareness about the prevention of sexual harassment in companies and has personally handled more than 45 plus cases of sexual harassment complaints. She's worked for companies like JLL, Polaris, and Stratton Dobbs and Singh's Arc Infometrics HR and BP roles. She was a gender sensitivity consultant with BCP Associates, a labor law firm for 5 years, and later worked with Kelp HR as head of delivery for both PoSH and DEI practices. Currently, she is freelance consulting doing PoSH and POXO work for TSC Foundation. She contributes actively to Women's Web and LinkedIn on PoSH and women empowerment. And that is about Aparna. And we've also had Aparna working with us. So I would vouch for how wonderfully the experience usually flows out. And we're going to see that in the session today. And we also have Shamli here. Shamli is a dedicated educator and a legal professional with commitment to rights based education. She currently serves as a faculty member at KLE Law College, Bangalore, where she imparts knowledge in various domains of law, including jurisprudence, family law, human rights, and torts. Having completed her bachelor's degree in law from ILA Pune, Shamli pursued passion for legal studies by obtaining her master's from Azim Premji University. Her academic journey has equipped her with profound knowledge of understanding of legal principles, and she has a nuanced perspective on human rights issues. And she's also written and worked actively on different intersections related to law. And she comes with the social science understanding that one has to have behind law. And her course in law and development equips her to understand the aspect of such laws which are meant for social welfare better. And yeah, really excited to just have both of them on this panel, and can't wait to see what unfolds today's discussion. So, the insights on the proposed bill we are going to talk about. So, this amendment has actually been doing the rounds, and I'm guessing a lot of people have already been asking us about the amendments today. So I would like to open the floor to Shamli to provide her inputs on and explain us what these amendments are and what is the law saying right now, and is it really something that is it a bill or is it an act? So a little bit of insight on all of this from Shamli would really help us set the tone for today's session. And any questions you have, please leave them in the chat box. And we would like to also address them at the end of the session as much as possible. Okay, over to you, Shamli.
Yes. I hope I'm audible. Hello, everyone. So let me begin with briefly explaining how passing of a bill to an act happens. So we have two houses of parliament, Lok Sabha and Rajya Sabha, and a bill can be introduced either by government, which is called as a government bill, and then there's something called as a private member's bill, where a bill is introduced by a member of the parliament. Now, it can be introduced in either of the houses of parliament. Then once it is introduced, you also have to, I mean, the person who is introducing the bill also has to give statement of reasons and objects, right? Um, and then the bill is, forwarded to, if it is passed in that house, then it is forwarded to the next house. If it is passed, I mean, if it is introduced in Lok Sabha, then it moves on to Rajya Sabha. And if it is passed in Rajya Sabha, then the secretariat of that house will pass this bill to the president for the assent. And once the presidential assent is given to a particular bill, then it becomes an act. And same goes for amendments as well. Right now, we need to understand that this proposed amendment is at a very initial stage. It is just introduced in Rajya Sabha. And as of now, it's not been even discussed yet. So we have a long time ahead, for it to become, I mean, an amendment act. To introduce a little bit about the amendment, this amendment was, it is a private member's bill, right? Now, it is introduced by Dr. Sasmit Patra on February 2nd, 2024. Now, this bill is trying to amend Section 9 of the PoSH Act that talks about the timeline for filing a complaint of sexual harassment. This bill seeks to extend the timeline. The existing timeline is 3 months. The bill seeks to extend the timeline to 1 year. At the same time, the bill is also trying to amend Section 10. With the amendment, it is seeking to remove the option of conciliation completely. Right? So the option of conciliation is available prior to the actual inquiry starts with the internal committee. So the bill is seeking to remove that option completely. So that is about the amendment that we're talking about right now. As we go ahead with the discussion, I would briefly like to also talk about a previous amendment which was proposed in 2023. So yes, once we go ahead with the discussion, maybe we can talk about that as well, because it is important, because it is exactly at a contrast with the current new amendment bill. So yeah.
Okay, thank you so much for that, Shamli. I just wanted to ask you if what is the stage? I don't know if you've touched upon it, but what is the stage that the bill is in right now? And what necessitates it? What exactly are these amendments that are proposed? And yeah, if you could touch upon that.
Yes. So as I already mentioned that right now it's in a very initial stage, that it is just introduced in Rajya Sabha and it's not even yet discussed. This Yes, the status that I recently went through, that it's at the stage of not even yet discussed. So we have a further, what I previously explained, the stages of a bill becoming an act. We have a lot of stages to cover still. Touching upon what the amendment is about, the amendment is trying to increase or extend the time limit for, that is the limitation period for filing a complaint of sexual harassment from 3 months to 1 year. Now, this 1 year can be if there are multiple instances of harassment, then in that case, 1 year from the last instance of harassment. This is the first part of it. The second part of the amendment talks about completely removing the option of conciliation, which is given under Section 10 of the current Act.
Okay. And based on these amendments, I would like to ask Aparna now that what does she think that as on a preliminary level of discussion, how do you think extension of time will affect the current PoSH Act that we have as it is now?
So I think one of the questions that already came up in the chat box is why has a conciliation removal has been proposed? So there is this input, I wouldn't say just feeling, but input that because there is conciliation, there is a possibility of influence and coercion. So, and we're already talking about people in power, and there's a power play always. Sexual harassment at the workplace, it's always not just because of interest, sexual interest. It is also because it's a power play. It's a way to put the woman down. So since that is a very established and well-known fact, having conciliation around kind of probably gives an additional weapon in somebody with the power to kind of settle it have a kind of out of court settlement that could happen. So that is something that has been mentioned in the amendment proposal itself. Dr. Sasmit has mentioned that as well. So that is where probably it's coming from. So if you ask me about the extension, so sexual harassment is a very personal feeling. I mean, it's a very personal feeling, and it can be very traumatizing for the victim. So most of the time, it takes women time to cope up and muster up the courage to come up and complain. So that is why the there's a time period of 3 months, and and then the IC has the power to extend it by another 3 more months. We're talking about 6 months. And from my experience, I've seen that it is again completely personal. I've seen young women who have not without batting an eyelid fought against very senior director level people and won cases. But I've also seen people, it is also, there are sometimes if it takes courage to come up, and sometimes if the person is in power, a direct reporting authority or the head of that department, then it becomes difficult. So women might wait for that person to leave, or they themselves, before leaving the system, they complain when they're during an exit interview. So that time period is something that cannot be defined according to me. And since it's very personal, it might take 6 months or 1 year or 2 years for somebody to bring it up. My own personal thing is I took 17 years to talk about a trauma that I went through in school. So it's really personal. So from 3 months to a year, I feel it is not, it doesn't, I don't know how much of huge difference it will make, because by talking about by extending it by a year, we are reducing making the investigation more difficult. You might lose out on finding facts and evidences. 1 year is a long time. People might leave. You might not have records of the meetings that have happened or people who attended. Witnesses may not be available. Even if they're available, they may not remember what happened. So it may actually, a 1 year extension, I feel, from my experience, I feel it should be left to the IC. Me leaving it open and trusting the IC with deciding how much time can be given. Maybe instead of 3 months more, maybe we can go up to 1 year. But by straight away making it 1 year, I feel we are making it, there could be a possibility. One good thing is that you're encouraging people. More victims may come up and talk. They will have, they may feel more comfortable. They might be able to gather emotional strength and objectivity during this time. They'll be able to come up and talk. But it is also challenging to gather accurate evidence. It could also create an opportunity for people to create malicious accusations, because you have a year to make up, right? So that is something that could come up as an objection. The resistance from the rest of the employees, rest of the organization, could be based on the fact that you had 1 year to cook it up. And when somebody goes through, when somebody is a victim of sexual harassment, closure is very important. By leaving it open for such a long time, let's say if I'm a victim and I think, okay, there is time, let me think about it. During that time, somebody might dissuade me from coming up and complaining. The positive side is that by then somebody gives me courage to come and talk. So there are both positives and negatives. So I guess it's said that, if if you're talking about bullying also, if a bully knows that I'm considering reporting about it, generally in bullying also issues also, if the bully knows that the victim is looking at considering talking about it, we might generally think that they will stop it. It actually doesn't work that way. They increase it. Typically, that's what happens. So if we are giving so much time and we are still hesitating, while I'm considering that what if maybe I should go complain, but I've not still done that, there's a possibility that the behavior might repeat, making it more difficult for the victim, and they might quit. The environment could become more hostile. If you ask me, for the victim, even if there is no retaliation, even if there is no bullying from the other side, me as a victim it might weigh down on me. So little 1 year seems a little longer for me.
Yeah. Wonderfully said, Aparna. Just wanted to bring in a technical explanation from Shamli at this point on, like you mentioned, that it is difficult to. I'm not audible. Okay. Am I audible now? Is it better? Okay. So
Yeah,
what?
you are clear.
I can hear you.
Okay, thank you. So what if, like on that point of evidence collection that Aparna has mentioned, I just wanted to ask Shamli if she can explain us how the evidence collection happens in PoSH, and if there is a view on personally, like if there is a view on why it would be so difficult, because I think in criminal law the procedure is slightly different, and in PoSH law the procedure is slightly different. PoSH law being a civil law has its own procedure that we follow, and as IC members, the powers are also limited on how much you can conduct investigations. So if Shamli could throw light on the difference of the process, so that we can understand why such an extension can be a little bit difficult for IC members to process.
Yes, so I think we need to understand two different ways of procedures. Uh, so in criminal proceedings, what happens? There's a rule provided by Evidence Act that the establishment of guilt has to be proven beyond reasonable doubt. What that means is that because the consequences of conviction in a criminal case are very severe, you have to prove the guilt, showing all kinds of evidences so that there is no doubt left against the guilt of the person. Now, Evidence Act, the hard and fast rules of Evidence Act do not apply to the IC proceedings in PoSH. In PoSH, we have a rule which is called as preponderance of possibilities. Uh, we need to recognize something, that these instances of sexual harassment, they don't usually happen in public. They usually happen in isolation, right? So it becomes difficult to gather evidence. I mean, they happen in such circumstances where it's difficult to get evidence. So securing evidence like, let's say, video footages, recordings, WhatsApp messages, screenshots, it's not always possible. Right, so we cannot completely depend on evidence. So here, the scenario is the victim's words against the perpetrator's word, and that is why in PoSH cases, because it is a civil proceeding, we have to follow a rule of preponderance of possibilities, which means that by showing an existing proven fact, one can see the possibility of that event happening more than it not happening. Right, so we have to, so for example, in case of absence of evidence, the IC has to believe that the incident has happened looking at a particular uh, fact, which in criminal case might not have that much weight. So so yes, that, and also there's one more point I wanted to yes, there's something called as a prudence man test. So looking at the scenario which is presented by the parties, what a prudent man thinks must have happened is what is believed by IC, and not beyond reasonable doubt and hard and fast rules of the Evidence Act, because PoSH proceedings are of civil nature.
Mentioned you're referring to reasonable person standard, something close to.
Yes.
Okay, so since the IC has people from within the organization, and for a reasonable person to finds it offensive, which means, I mean, people from the same organizations, we expect them to think on the same lines in various matters. So we expect that there is a reasonable person standard for a if for the entire IC feels that there is that it could have happened, or it is definitely offensive, something that should not have happened. It's not a professional behavior, and then we kind of go with it. That's what I said.
Yeah, I would like to bring in this example that actually we saw at like wherein there was a manager who, after a late work gathering, offered the intern that I will drop you home. And now this girl has refused once, and then he said that no, it is late in the night, I will drop you home. And then he insisted, and then he went to drop her to her apartment, and he went to her building, and there was a record of, say, some 45 minutes of in and out. in the building guard book entry, through which it was determined that he spent some time at her house. So now at this point, there are no witnesses. Nobody has seen what he has done inside. But if it is left to criminal law, then you have to prove beyond reasonable doubt that he has committed that. And it is so difficult in such a scenario that you can determine from the preponderance of possibility rule that firstly she said no for him to drop her home. She was uncomfortable with it. He insisted. And why did he enter the house and stay for 45 minutes in the house of an intern at such late hours? So there is a possibility, it is the most probable situation that she is telling the truth and she does not have any evidence to prove the same, because it is not an expected incident that somebody goes in the mind with. And at a workplace, you also have this, what do you call, a little bit of trust that they are your colleagues and you do spend time in isolation with people. So, if something happens in these scenarios, applying the principle of beyond reasonable doubt will only take away the essence of the law, and to uplift the spirit of the law as a civil law, where the powers are also limited. It's not like the action being taken against the respondent is criminal action. We are not sentencing them to prison time or anything of that sort. As an IC member, we are only providing them uh, the maximum we can do is maybe a termination, or in a rarest of the rare case scenario where we see that there's a monetary loss suffered by the person, there's a monetary compensation given. So the maximum remedy that is being given is also of civil nature. So it is only fair to apply the laws in a civil manner, though the nature might look criminal. So that's the difference that I just wanted to elaborate on with that example. But that being said, now I wanted to also bring us to the understanding of the process of conciliation. Why do you think, this question is to both of you, that why do you think the process of conciliation exists? And what is the benefit of it? Either of you can take it up based on.
Yeah, I can begin. And from a very practical point of view, one is, as a layman, if I can avoid the legal process, then I would like that. So, that's one that's a big motivator. And as an organization, since, I'm, more from a corporate person, so I would also say that as an organization, I would prefer that case doesn't have to be a huge amount of legal procedure and I have to report it. So if it can be ended with a simple conciliation, out of court settlement without calling, witness cross examination and the whole process, then I would prefer that. So I think it would have kind of a preferred mode to resolve things, especially if somebody doesn't want to go through a legal process of being questioned. But the other practical possibility that I've seen very often when it comes to conciliation, is that romantic relationships, when they go sour, let's say two people are in a relationship, they break up, and but the boy continues to approach the girl for in any form, sometimes talking, sometimes continues to make comments, or continues to bother, and the breakup hasn't despite the breakup, he continues to bother her. And the woman comes and complains. In those situations, there is still some warmth left. They do not want the lady might not want the other person to be punished very severely. She wouldn't want the other person to lose his job, career getting affected, very serious punishment they may not be looking for. not just in romantic relationships, even otherwise, sometimes colleagues that we work with closely, I just want him to stop. I don't want him to continue bothering me. I don't like this should, I don't like this behavior, but I'm not looking at punishing this person. I just want this behavior to stop. Many times, maybe the tolerance or, whatever you would want to continue working. So sometimes, or the pity, out of pity, or whatever may be the reasons, multiple reasons, people don't want a serious action to be taken. So in those cases, in those situations, the conciliation were a very handy tool for the IC to kind of resolve. And of course, we're giving a powerful tool in the hand of the complainant, making them feel nice. I mean, like you feel good that the decision was in your hand. At any point, I can, as a victim, I can say, look, I'm not okay with conciliation. I'm going to go through a inquiry. So it's in the complainant's hand. So it makes them feel empowered, I feel. So these are some things that coming to my mind. Shamli.
Right, yes, to briefly explain the legal aspect of it, conciliation is a voluntary process, right, which gives the option to the parties whether they want a third party, which is impartial, which is neutral, to help them resolve the issue. Now, when the amendment proposed to remove conciliation, they have given certain reasons for it in the statement of reasons and object. So, one of the reasons which was given is that we need to understand that conciliation might be fruitful for, let's say, matters of contractual matters and disputes arising out of contractual matters. But it may not be same for matters of sexual harassment. At the same time, conciliation may result into a compromise which will sort of take away the dignity of the woman, is one of the possibilities. Also, another of the reasons states that we need to take into consideration that there is always a possibility of undue influence and, this aggrieved woman being coerced into opting for conciliation. So these were some of the reasons which were given by the uh, in the introduction of the act bill. But at the same time, we also have to take into consideration that a lot of times people look at these formal inquiries, they equate these formal inquiries with that of legal proceedings, like a court proceeding. And that is why it kind of works as a deterrence for them to file the complaint in the first place. Right. So also we have to take into consideration this one point, that this option of conciliation is at the instance of the aggrieved woman, and it's not the perpetrator, the accused person, the respondent, who gets to choose it. It's at the instance, at the request of the woman, they can opt for conciliation. So yes.
Thank you for that, Shamli. I actually wanted to also add here that in PoSH law, it is not intent, but impact matters the most. So when we are talking about impact, just a little addition to what you both said is that when we are talking about impact and not intent, there might be cases where there is probably a generation gap or a cultural misunderstanding, or a person with maybe more the different mindsets. So all of these situations also arise, such situations for us wherein in a workplace it is definitely uncomfortable for you to reach out to somebody, especially when there is a power dynamic in terms of gender, or in terms of job roles. Like if someone's not understanding, it always helps to take help from, a conciliation situation, and having the IC panel in front of you, who is going to support you in reaching out for a remedy. And in there are cases where the respondents don't even know that what they said has created this kind of an impact on the other party, and the other party might not feel very comfortable just going and telling the person that, hey, this made me uncomfortable, because of the kind of society we live in. So conciliation in such situations acts like a boon, because then they can just say that, hey, I have nothing against the person. I don't want their life to get ruined after this complaint. And I don't want this complaint to also, uh, create an issue, because otherwise this person is okay. I just need to tell them that do not behave like this with anyone, or these things might be hurting my sentiments. And and there are respondents who are very wholesomely understanding of these things, and they are like very open to the conciliation process, where they apologize profusely, wholeheartedly, and also work towards, like, uh, becoming a better person after such conciliation processes. And they understand that there is a certain kind of sensitivity that they should keep in mind. So it also is a very rehabilitatory provision, I must say. So
So
yeah.
I guess it's a very nice point that you brought forward, Meenakshi. We ultimately, I remember a senior who always says that we are talking about a colleague, we are not talking about a criminal there. So if there is an opportunity for them to change, if it was a mistake, it was a crossing a line, then conciliation gives an opportunity to for them to make amends and change, right? So I guess it's a very valid point. And instead of completely doing away with it, we are actually taking away a very powerful tool. And instead, if there can be more clarity in terms of how conciliation can work better, I've seen that when I speak to many people, I feel there is a lot of ambiguity around how conciliation works itself. In the beginning of, let's say, I'm talking about 2014 or so, 14, 15, we have done conciliation in between, which I know that is how it should not be done, right? So it's it where
Do you
when
clarify
does
on
it
that?
have
What
to
is
be
in
done?
between, Aparna?
In between, in the sense, like, the inquiry is done, but if the inquiry is completed, then the IC is like all set to give the maximum punishment of termination. But in between, the complainant came and said, look, I don't want him to be terminated. I would like to go in for conciliation because I don't want to destroy his career. It is true that I'm uncomfortable, all that, but I don't want to destroy his career. So either you go in for conciliation, or otherwise I will withdraw the complaint right now. And if a complainant wants to withdraw a complaint, we can't stop her. And then there is, you know, you can't, the company cannot, there is also a problem of double jeopardy, or you have to consider those things if the company takes it up under a code of conduct or something. So there's a lot of, it becomes complex. So having, so that clarity, if that comes in as to when conciliation should be done, how it should be done, if more clarity can be provided and making it a little more accessible and understandable to everybody instead of taking it away, I think that would make more sense.
Agreed. Are there any other comments on this, Shamli, or
I think same things that I think you both have mentioned, that PoSH Act is an ameliorating act, something which will lead to bettering the system. Uh, and the point of the act is not to punish anyone.
yeah?
Conciliation is a good option. The doing away with it does not make any sense.
Uh, do you think, like, maybe there's a solution to it? Like, for example, they have probably given the doing away with by their own reasoning. So I'm just thinking out loud here with you all that do you think there's a solution to this? For example, the conciliation process, especially, sometimes we have seen that, like, maybe there is a pressure on the complainant to opt for conciliation, or like, I'm just talking practically that there might be instances, and I wouldn't be surprised if there are any, wherein uh, the IC members are kind of pushing, or like, even though they are not supposed to, but they will push towards a conciliation, say, because it saves their time and effort and whatnot. Like, I think it's a more less tedious procedure for them to go through, and IC members cannot get paid for working as IC members. So maybe they would push for conciliation just to make sure that no harm done, or like whatever. So, do you think there's a solution to this other than completely doing away with the process of conciliation?
I would like to bring in the 2022 amendment here. It was introduced in 2023, late, that is in December, and there hasn't been any much of an like what updates on that. So I haven't had a chance to get more what status update of it. So what the that this previous amendment was trying to do, they were trying to do away with the LC, that is local committee, and substituting LC with employment tribunal. So the aggrieved woman will now have three options. One is conciliation, second, the IC inquiry, and third one, a legal trial, right? So a lot of time it happens that in-house redressal system may not command that kind of confidence, which maybe a legal trial will, right? So I felt like this, the previous amendment, which was introduced by one of the MPs, I forgot the name, which was much more, it made much more sense to me, because here the aggrieved woman will get to pick from three different options. So the 2022 amendment was actually trying to give more redressal options, more modes of redressal, whereas the 2024 amendment is limiting the redressal options by completely removing conciliation.
Yeah. Yeah, and also just reminding that this is just bills and it's not an amendment, because we have received at Kelp like these queries that, okay, what should we do now? It's already passed. And they send me the bill circular. So I think that is, was I stuck or something? Sorry, I was just checking. Yeah. So, yeah, so these are doubts that really panicked people. Like these two bills, especially the latest bill, has panicked people and has created a lot of anxiety among people that it has already passed or not. So, just bringing in and reiterating that it has not passed yet and it is still in a process stage. So, now I wanted to come to the point that what if this is passed? Okay. So what if this is passed and conciliation process is done away with and the extension of time limit has gone to 1 year? Then what should companies expect out of such a situation then? What are the things that we need to keep in mind?
I feel awareness will help. Uh, People's confidence and employees' confidence in IC has to go up. On the other hand, ICs also have to be equipped better. More deep dive trainings by if they're bringing in such an amendment, I would also think that they should bring in more clarity of what is the power IC wheels and what is the limit. The one thing I've always felt a gap is that if after the end of a inquiry, till what can we go? Where does the IC's role stop and where does HR take over? And then the IC is most of the time cut off. So, the entire redressal process, if we are calling it a redressal mechanism, but it actually doesn't, I have not seen that happen. IC gets cut off. After that, HR takes over. So we do not know if it was done right, if it was done right. Those things are always a question. So if there is more, more clarity emerging from such huge changes, that will be nice. So from company point of view, I think we will need a lot of awareness, confidence building, trainings, not just for the people, but for ICs, so that they are in a position to handle inquiries better in a more transparent and more fair and objective manner. And when and people are um, the sensitization for victims or complainants that they should not, what is the benefits of actually bringing it up and taking it to a closure, and the fact that it is not scary, it's not necessarily a scary process. So more awareness around that will help people pick up and come and talk, because the perception can be anything. If people get to hear that there is no conciliation and you have to go through only a legal full an inquiry process, we don't know what's running in people's mind. So giving clarity around that to the layman, I feel will help.
Right. Thank you, Aparna, for that. Shamli, any thoughts on how the implementation can happen if this is passed?
Some technical changes have to be made. For example, redrafting, revising the PoSH policy, creating awareness amongst the employees about the extension. And then, I mean, again, IC also needs to be trained differently because now there is no conciliation. So the what complaint is completely dependent on IC. So some expert advice, some experts have to be brought in to maybe train IC better.
Right. And also, given that I think if I were to give my 2 cents as well on this, I feel like firstly, if we are talking about the time extension, IC needs to get some more higher level of training on how to do evidence collection. Because in fact, the first case I handled was a case that happened 1 year ago. And I had to take it in because there was no retrieval done back then. There were reasons. We recorded it in writing and we did it. But the fact that it happened 1 year ago, it was really the word of everybody. And it was so like, even cases which are 7 to 8 months old, it is so difficult to collect evidence. So we need a special kind of training. We need to also approach people who have probably left the system. And maybe those kind of things also need to be considered, that can we really look forward to IC powers where they can actually summon people from outside of the company to come and tell you, like, I don't know what authority, but like we would require that, because in a year, a company's face can change completely.
IT
Especially,
policy. Maybe we have to redefine the IT policy of the organization, because record keeping. How
yeah,
long do people keep records? How long do the security videos, the CCTV footages,
yeah,
or the conference room bookings, meeting bookings, email storing of emails and retrieval. So all of that might have to be redone. If
yeah.
you're looking
The
at
entire company's foundation will have to change for the amendment to work for us. And also, like, doing away with conciliation would also make I see like more make for more cases to be filed, definitely, which are really old, or maybe so IC's work will definitely have to increase. So is there a capacitation building? Because I don't think 4 or 5 IC members who are handling so many people can actually take on cases that are like, so large in number and from so long ago. And how much are they documenting? There is no lack of there due to lack of conciliation. I think even matters where there is misunderstanding. I'm not saying that it is fair for people to get away with doing things. And it's not like conciliation is somewhere where people are getting away with doing things. It is holding accountable and also bringing people into the purview of PoSH. But just saying that, like, that not being there will actually increase the uh, burden of IC to go through little matters where it is again a situation where both of them are willing to agree. But we have to conduct a formal inquiry process just for the sake of the legal formality of it all. And it might become a little tedious, and a lot of people might not even come forward with the complaints with the conciliation going away, because they might feel like it is a large process. And
yeah.
in fact, as a person who has been seeing PoSH and also criminal law, I feel like victims do really, victims or survivor, whatever terminology we are using, um, uh, they do struggle with coming and complaining. So maybe doing away with conciliation might actually make a big difficulty for them to file that complaint. And definitely, PoSH policies will have to reflect that, and all of those trainings need to be done. Yeah. I think that being said, I would like to open it to questions. I'm sure that we have answered most of the questions which were coming in the comments. Is there anything that was left unaddressed? Maybe we can take up.
So I think not very connected to the topic, but there's a question that is how to deal if the person has already left the company.
Yeah.
So Sharad, would you like to share more information, more clarity on what are you asking from the victim point of view or the respondent point of view? So if the Shamli, would you like to take it? We can put both scenarios, we can say. If a respondent has left the organization, if the accused person is left and the complainant is now bringing it up, I feel there is no jurisdiction. There's nothing. The only option is to go to the police. In case if it is the complainant who has left the organization, but they are bringing it up, we can still, doesn't have to be an employee to complain. So we can take it up. Right. I think
Yeah.
that's good.
Yeah.
Yeah, that's it.
Yeah.
Yeah.
Thank you for answering my question. Thank you.
No problem.
Okay. I think a lot of coverage on the issue was done. If there are any further questions or if there are any things that we have left unanswered, we've tried to answer most of the questions that came in the chat also over there itself. So if there are any doubts further, so please reach out to us at Kelp HR. The email ID is there in my screen as well, my background. So Shankar has raised their hand. Could you please?
Yeah.
Yeah.
Hi.
Hi.
Just wanted to check with the increase in the period, maintenance of data, would be very tough and PoSH becomes applicable 10 employee plus. For smaller organizations, it will be a really very, very tedious task. For larger organizations who have got CCTVs or processes, all that is fine. A 10 plus people company, they have a lot of, they don't have proper email servers, they do not have that much CCTV coverage, multi-locational issues could be there. It could happen anywhere. So this act seems to be complicating things rather than solving problems, especially for smaller organizations. For larger organization, extension from 6 months to 1 year to 2 years is just managing the data for that time. For smaller organizations, it's really a very tough task to keep all of this information together. And especially after the act has happened, after 1 year, where will you go and search? Many times we don't find an important file which we opened 1 year back. This becomes a little bit tricky. I don't know how the act plans to handle and make it practical rather than a mechanism which is misused by the statutory bodies, for lack of better word.
Right. Makes sense. Fair enough. I mean, we just have to wait and watch at this point and see where it goes. Thank you, Shankar, for your input. And Shruti had one question. I think this is the last question that we or statement.
Hi everyone. Firstly, thank you for organizing such an insightful session. My question is that, while I understand that this is at a bill stage, but if the ability to conciliation is being taken away, whether it will in fact become detrimental to the aggrieved party, because like we discussed that, in certain cases the aggrieved party may not want to go all out and just ensure that it's done as a deterrence, against the respondent. But with such cases, whether it will in fact counterproductively impact more women coming ahead and this issues being unresolved.
So I have seen that, Shruti, it's a very valid concern. We've been definitely talking about that. So one thing I've seen is that sometimes when people don't, there are times when complainants do not, victims do not want to take up a make up a proper case. Like an example that I can give you is there was a case where the complainant, the victim herself said, look, I know it is not, it's I know it's not big enough for this person to be terminator or anything. But at the same time, I'm not going to keep quiet with all the comments he's, discriminating comments he's making. He took a picture but I feel it's not going to, he's not, I'll have to continue working with him every day. We are in the same team. We have to continue to look at each other and work. So I don't want to take up a case. So I don't want to go to IC. So instead, I just want this to stop. I want HR to handle it. Under the code of conduct, if he's misbehaving or something like that, do something like that, I'm not willing to give a case which will go to IC. I don't want to write to IC. Sometimes that is another way that sometimes these issues could end up getting resolved. But the advantage of the IC, the whole spirit of the IC and the PoSH Act is that the principles of natural justice and the transparency, the objectivity that the IC brings in cannot be replaced by an internal investigation procedure. It's we may say that there's fairly done or anything, but unless the PoSH Act, unlike in the PoSH Act where we are obliged to share information, we have to be transparent. That may not happen there, so that you don't have visibility of what exactly happened, what is the resolution, and if I have a problem, I don't have a way to change it or apply. So while if we have conciliation and then that doesn't go through, you still have the option of going through a full-fledged inquiry. So it's the act and IC and the inquiry it's a very empowering mechanism. So, and having a conciliation and then if it could fail and you go on to the inquiry, or you choose conciliation and stop there, so the options are more. So having it around definitely is empowering, and it's a fantastic thing to have. I would feel very, it will be a setback if conciliation is taken away.
Aparna M and Shamli Smita here, I just wanted to give it one spin, and just from the experiences that we have had as an external member, what I'm thinking is taking away conciliation, meaning every case, even if it is trivial in nature, will reach IC. Now, what was important is how IC looks at it. Do they give apology as an outcome? Do they give warning as an outcome? That is depending on the severity. I think just giving it as positive spin is that every complaint, however trivial it is, has to come to IC, not for conciliation, but for proceedings. I'm just going to hang on to that positive aspect is what I feel. Yeah.
I would agree. And there was somebody had made a comment. I don't know if the comment is still there. Somebody said, so how do you define trivial? I mean, what is it when in a sexual harassment complaint? I don't know if there is a small, large, extra large. Can you define? It's very difficult, right? Like Meenakshi said, it's the impact. What's okay to do? It might sound trivial to you, but it has had a huge impact on me for various reasons, because of the way I've been brought up, my culture, my DNA is completely different from you. So for me, it's very serious. So that's something we tell managers also, right? Don't trivialize anything, just bring it to IC. So yeah, Smita, I would, it's very difficult to kind of slot sexual harassment complaints, saying that it is small, trivial, or very serious. Depends on the person. So giving them the option to encouraging them to go through the inquiry process is something that, it's helpful. Yes.
Aparna ma'am,
Yes.
just wanted to ask you one thing. What is the reason behind the changing from 90 days to 1 year? Because see, normally we are a human being. We are not aware what happened prior to 1 year back. So, and the evidence at that time, the collecting evidence is more difficult.
Correct.
Yeah.
Shamli, I think you can take
Shamli,
that.
you can give that reason. What was the reasoning given for such a extension?
Yes. The reason which was given was that the woman not, it may not be that the woman will cope with that particular instance very quickly. Hello. So in that case, this extension of from 3 to 1 year will give her some time to cope with that harassment instance. I'm so sorry. Yes, and also sometimes this realization comes later, right? Not necessarily in 3 months. It comes later that I should have said something. I should have filed a complaint. So yeah.
Yeah.
But ma'am, I think so. Madam, 1 year is a too much time, no, ma'am. Suppose if an employee, has, a woman has complained in IC, and then the person against whom they have complained here left the job after completion of 6 months due to whatever reason, then what will happen?
Then there is no jurisdiction for the person to entertain the complaint
But
only, because the
no,
response has to be in the company for you to take up the case. So
that is
it's
okay,
not
ma'am.
in the jurisdiction part, but I mean, I feel like it's I agree with you on this, that it is a very difficult line to tread, but that's what we have been also saying in one of the initial discussions, that like it is definitely a difficult line to tread if it's a old case. But do we I mean, there are pros and cons to everything that comes. So if these are the cons, then there are also pros, that more people will feel empowered to file complaints, maybe once they are ready to file those complaints and they feel uh, like they are ready for it, ready to deal with it, because now they've emotionally dealt with it. Now they have to deal with it in the case proceedings or whatever. So that could be a possibility on why this came forward. But let's see what happens when the bill comes to. So one last closing note, I think if you both can, if either of you can give what should have been the amendments, like from your understanding of the law. Maybe Aparna, because of the industry experience, what do you think should have been possible amendments to the PoSH Act if we were to leave it on a dreamy note? Wishful thinking.
I would kind of repeat what I think I said already, that I felt there is a gap where as to where the IC's role ends. When you're talking about redressal mechanism, then the IC should be involved end to end. So empowering IC to take it to closure, then it will also, I feel if that is done, there is also the possibility that sometimes companies take their own decision. And if you're writing termination, sometimes it is like they ask the employee to leave, and then you allow the person to the perpetrator to go repeat that mistake somewhere else. So those are there have been cases which have gone public that way also, and I've seen it happen practically. So while an innocent person should not be punished, but if there is somebody who has done it knowingly, there has been somebody has sexually harassed and it is proven, then that punishment also should have been seen through. So empowering the IC further, allowing the redressal mechanism to actually take it through to closure, I feel would be great. And a support mechanism for victims is still an option if that can be made compulsory.
Yeah. Maybe making the law gender neutral for everyone.
Yeah.
Wishful
Absolutely.
thinking.
Absolutely. Yeah,
Yeah.
we did a survey also. We had a lot of previous year. Then when I was in Kelp, when we did the survey also, family with the there was quite a bit of male um, uh, victims as well. They said they were sexually harassed at the workplace. Recently, I was talking to somebody in the a politician from Malaysia, and there also they are talking about men. So there is a different spin that is going on. So making it gender neutral will be nice. Yes.
Yeah. So I think that being said, we are coming to an end of today's session time. So I would also, somebody has asked if a recording of this can be available. So yes, on YouTube, you can find Kelp HR and ILA if you write. You will find this forever in the YouTube. So whenever you want to revisit this, just to go through, you can. And sorry, Anupama, if it's a quick question, we can probably answer it off and end today's session. Anupama?
Yeah, it's actually food for thought.
Yeah.
And it really came from Aparna's last point, which was that even if somebody is guilty of sexual harassment and we have punished them through whatever process in the IC. I think the larger question is, what do we want them to do in the future? Do we want to, for lack of a better word, rehabilitate them? Or, do we want them to suffer for life in terms of their career? So that is a very key question. We need to figure this one out. Otherwise, it's like what we talk about in India in terms of the jail reforms, that we send people to prison, but we don't do anything to make sure they don't repeat these mistakes. Because I
Yeah.
think even them, they have a right to a career. Because they must be supporting families and so on and so forth. So, that is something that we as think tanks should get together and maybe hash out for our political parties to take forward.
Yes, that's wonderful to think. That's what I was saying, that there is so much rehabilitation that comes in. And thank you for that input, that PoSH is a rehabilitative aspect where we are trying to improve workspaces, not by canceling everyone and removing them from the workspace, but all reinforcing the mindsets within the workforces. So,
Absolutely.
Absolutely. Thank you so much. Very, very insightful.
yes.
Thank you.
Bye-bye.
Thanks. Bye.
Yeah. Thank you, everyone.
Thanks. Thanks, Meenakshi. Thanks, Shamli.
And
Thank you.
thank
Kelp
you,
team.
Ami and
Bye-bye.
Aparna, for your really insightful thoughts for all of us. And it was really a fun session for me. I hope you guys had fun too. And
We
I
did.
hope all the audience had fun too. So thank you so much, everyone.
Thank you.
Thank you all.
Bye-bye.
Thank you.
Thank you.
Thank
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 you,
you,
ma'am.
everyone. Thank you.
Thank you all. Thank you.